I'm going to call the next case I'm calling is 2019-46, State of Arkansas versus Andrew Lampkin.
Your Honor, Mr. Lampkin has, I think, just very recently been appointed to us. I have actually thought he was ours. I've seen him at the jail a couple of times, including yesterday. If you could, now that I know that he is ours, I think the docket may reflect that this is attorney status hearing today, but he is ours now, Judge. And now that I know that he's ours, if it's going to require a trial, then I would ask that it be set over until, are you here the 15th of August, Your Honor?
Yes.
If we could set him over until that date.
I'm setting him to reappear on August 15th. The case is set on the current scheduling order for set during the week of August 19th.
Your Honor, Mr. Lampkin is here. It is my understanding that in previous cases in Marion County that evaluations have been sought by the defense, and he has been evaluated in those cases. Obviously, that is an issue that now that I know that I am his attorney, that I will explore with him. And I just want to announce that in open court.
Is Mr. Wallace representative? Who's representing him?
I don't. Is he active in Marion County now? That's those from previous cases, Your Honor. It just concerns me, Judge, that if he's had evaluations before in previous cases, I need to at least explore that possibility with him.
You find about me being released on my own conscience?
Mr. Lampkin is currently on our scheduling order for trial on August 19th, and I'm putting him down to reappear on August 15th. You may be excused, sir. Court is calling next 2019-254, 2019-255. State of Arkansas versus Brian Herring.
Your Honor, I'll be representing Mr. Herring. We waive formal reading and enter a plea of not guilty to the charges.
You're representing him in both cases?
Yes, Your Honor.
I show that he's not been arraigned in 255.
He has not been, Your Honor. Mr. Herring has been incarcerated in the federal system for a period of time and has just recently been released.
Case 2019-255 on the charge of theft by receiving. How does Mr. Herring now plead?
Not guilty, Your Honor.
I'm going to set it on the scheduling order. We haven't filed 9/26 will be his final hearing date. It will be set during the week of October 21st.
That's fine.
The two cases are running together. I'm not joining them for trial at this point. I don't know anything about their similarity, whether they should be tried together.
I actually think it's the same fact circumstance. And that's what I need to get with the prosecutor's office about. Ruth and I were looking at it a few weeks ago. It appears to be the exact same thing charged two different ways, and that's something that I'll visit with them about. Does it show a bond for Mr. Herring?
$3,500 in 255, $7,500 in the other. So that'd be $11,000 if they're combined.
Yeah, the state has no objection to the bond being $3,500.
$3,500 in both of them.
$350.
Bond is $7,500 for both. All right. They're both set for trial during the week of October 26th with a plea deadline or final hearing deadline of September 26th.
Okay. If they would give you information on how would you plea out?
Anything else come up at this time?
Not at this time. We may ask to bring him back this afternoon.
All right. Next case the court is calling is 2019-259, State of Arkansas versus Tyler Lawrence Ackroyd. All right, based on a review of the application, the court is making the appointment of the Public Defender's Office to represent Mr. Ackroyd. This is for arraignment on a charge of residential burglary, theft, which is a Class B felony, theft of property, a Class D felony, resisting arrest, a Class A misdemeanor, and possession of drug paraphernalia, Class A misdemeanor. On those charges, how does the defendant now plead?
He pleads not guilty, Your Honor.
Plea of not guilty is noted. The Public Defender's Office, as I said, has been appointed. It's a Division III case, so I'm setting it down for reappearance on August 8th, which is Judge Putman's next date holding criminal matters in August 8th. Anything else to come before the court?
Your Honor, is his application reflected in, this is his wife and I was just speaking with, he works at Bascat, and we would like to get a reduction in his bond. We understand there would be restrictions on that considering what the charges are. But I hate for this young man to lose his job. His wife is young. I think he said that, do you have a family?
Yes, sir. Just me and my wife, but we just almost had our first child. We just had a miscarriage.
I can't hear you.
He said they do not have a family, Your Honor, as far as children. His wife just had a miscarriage. He has a residence that he can live in this area. He would live with his wife. You know, we would ask for a substantial reduction in his bond.
What says the state?
Can I have one second, please, Your Honor? You know, the state's concern, and I want to make sure it's the right case when I said it's the state's concern, and this one was, this individual was difficult to arrest, to saying at the least, and people who participated in this arrest also, Your Honor, also were given information by other employees at Bascat. I have no objection to his bond being appropriate, but we have some concern about the cooperation that was needed to extract this individual before we could get him arrested, Your Honor.
I just read the information, contains some information.
He had to be tased, and that always concerns the state, Your Honor, that when you have someone who's that non-cooperative, and the officers had to fight him to get him arrested, Your Honor.
I'm going to reduce the bond to $10,000. Cash as pro, I'm going to require that the defendant, if he is able to bond out, he remain in Baxter County and refrain from use of drugs or alcohol as a condition of his bond, and also that he remain gainful. Those would be conditions on the bond.
Your Honor, can we also request that he be drug tested weekly at probation and parole, please, Your Honor?
Yes. I'll make that a condition as well. You may be excused, sir. The next matter is the revocation list 2017-10, State of Arkansas versus Jared Willis. I have this case was set down for hearing today. Mr. Willis, do you have an attorney representing you on this matter?
Your Honor, he has filled out an application. We just got that this morning, Judge.
Willis, you're not employed.
Not at the moment. Well, I'm in jail.
When were you last employed?
Probably about a week before I got arrested.
Court's making the appointment of the public defender's office to represent Mr. Willis. Mr. Willis, you're before the court. This is the first appearance on a petition to revoke a suspended sentence. The public defender's office has been appointed to represent you. The petition to revoke filed July 19th of 2018 alleges that you violated conditions involving the requirement to report, to pay supervision fees, to pay fines, and cooperation, that you cooperate, and in this case it's alleged that you avoided since sometime in July of 2018 you have been evading supervision. You were an absconder. Those are the allegations contained in the petition. On those allegations, how does the defendant now plead?
Not true, Your Honor.
Is that what they're offering now? 120 days or CCC?
The court will set this matter down for hearing on August 1st. That will be the order of the court. You may be excused. Court is calling 2019-236, 2019 or 2018-299 State of Arkansas versus Jonathan Smith. There's another case, 2018-299, it's a revocation on the Division 3 docket that Judge Putman is handling. It's not on my docket, and I'm not taking it on my docket. We'll just proceed on 2019-236. He was arraigned before Judge Putman on June 27th, entered a plea of not guilty, and was put down for today's dates to reappear. The court has ordered a scheduling order in Mr. Smith's case, setting his trial for October 21st trial week and reappearance on September 12th. That'll be the order in the court. Anything further to be brought up at this time?
Senator, he had talked to me about a bond yesterday. His mother is here in the courtroom with him, and she had spoken to me before court started, and he would live with his mother, who lives here in Baxter County, and so he has a permanent place that he would live in. We know he'd be subject to the standard terms and conditions. I'll leave it to the court's sound discretion as to what his bond should be set at, but we think there should be a substantial reduction, Your Honor.
It has, on the original information, it was said as a no bond hold. Has there been any amendment to the bond on this matter?
On behalf of the state, Your Honor, our concern is we have 3 pending cases against this individual.
Are the rest of them on Judge Putman's docket as well?
We have 125 is on Judge Putnam's. 299 is on Judge Putnam's, Your Honor. And then there's 257, Your Honor.
Your Honor, we would ask the court to issue an order on the bond, and I think it just makes sense that after that is done, that this case be transferred to Division 3. If he's got 3 cases already in Division 3, it makes no sense to have 1 in Division 4.
State's answer, Your Honor, they all belong to me, so it does not bother me, Your Honor, wherever you want to move them to.
Well, I have no idea what the bond is on these other cases.
I'm sorry, Your Honor.
But, I do think, sort of,
You know, we have
as a general rule, short of capital murder, I generally feel like there ought to be a bond.
It's 20,000 on one case, Your Honor. 10,000 on another case, Your Honor.
Have you already made those bonds?
And then 10,000 on another case, Your Honor.
Given this would appear to be, and what the court knows about it, that the third or fourth offense of this debt, at least the defendant has been charged with, over obviously a previous conviction. And given the extreme nature of the allegations against him, the court's going to set bond at $100,000, cash approach. To be conditioned upon having to know. If he does make bond, I feel that he should wear an ankle monitor and not have any contact whatsoever with the alleged victim of this crime or any other crime. That would be the bond.
Your Honor.
That's just this case. Just this case. I'm not going to set bond in cases. And at this point, I will transfer this case to the Division 3 docket to be handled so one judge can handle it. Making it reappear, canceling my scheduling order, reappear August 8th. Not a judge.
I had a probation rep.
I'm done with it. 2019-260, State of Arkansas versus Todd Johnson. Mr. Johnson, do you have, you made arrangements to be represented by an attorney?
No, sir.
Do you have any plans to make arrangements for that?
No, sir.
Let me explain. You have a constitutional right to an attorney. What that means is you have the right to go out and hire the attorney of your choice. And you've got at least one felony charge among the charges against you. I'm about to arraign you on. So particularly in light of the fact that there's at least a felony you're being charged with, then you know, it's absolutely, I believe, imperative that you arrange for having an attorney and you ought to take it seriously. But even if you have just on the misdemeanors, you have that constitutional right to be represented by an attorney, and it's in your best interest to have an attorney. Now, the way it works is that you have that constitutional right to an attorney. The court, as long as you're hiring private counsel, the court doesn't do anything. The court doesn't have anything to do with it. That's your right to go out and hire an attorney of your choice.
Okay.
The court doesn't interfere. Now, if you determine in the process of trying to hire counsel that you cannot afford to hire an attorney, you need to understand that you have a constitutional right to an attorney, and the court will appoint an attorney for you. But you need to take action before you get an attorney appointed to you. It doesn't happen automatically. You're going to have to make application to the public defender's office. Those applications, we have them here in the court today. They're over at the jail. You fill out the application form and sign it and turn it in, and that'll get to the public defender's office, and then the court, a court, won't necessarily be myself, will review it and make a determination whether you qualify for the public defender's office and make the appointment.
Okay.
That's how you get an attorney. Either you go out and hire an attorney, or you fill out the application, one way or another.
Okay.
And so that's purely up to you. The charges you're facing are possession of drug paraphernalia related to methamphetamine, cocaine, heroin, or fentanyl. And that's a Class D felony. Carrying a weapon is a Class A misdemeanor, no liability insurance, and driving on a suspended license are violations. Those are the charges you're facing. On those charges, how do you now plead?
Guilty.
You're trying to enter a plea of guilty at this time? See, this is exactly why we needed to address the attorney issue first. You need an attorney to understand. If you plead
Can I
guilty
bond
right
out?
now, I can go ahead and sentence you.
Can I bond out?
Well, no, we'll get to that next. Mr. Cooper here is a public defender.
Not guilty.
All right. I'm entering your plea of not guilty, and directing that you make arrangements to get an attorney
Perfect.
in line with what I've told you. You're not done yet. You asked if you could bond out. Let me address that issue for you.
Your Honor, there's a hold on him out of Faulkner County. No bond.
Well, bond in your case has been set at this point at $5,000, but it was a hold out of another county, Faulkner County. If you post that bond, you're still gonna stay in jail.
Right.
For that, so, all right. You've been informed of what your bond is, you may be excused.
Your Honor, there's actually two bonds. He has a bond in 19-186 of $2,500 and 19-260 of $5,000, Your Honor.
Okay, there's a 186,
There's 19-186 also, Your Honor.
is that case, has he been arraigned on that?
There's a scheduling that I think he was arraigned on 5/30.
He's set on that 186, he's set for trial on my docket for the week of September 16th with a reappearance on August 1st. And I don't see anywhere on that case if you had a counsel appointed.
We've not, our file does not reflect there's been anybody appointed either, Your Honor.
So, to your knowledge, do you have an attorney on this other case that's just been pointed out to the court? Back in May, you were before the court?
I need a verbal response.
Yeah.
No.
All right. On the charges against you in that case are possession with purpose to deliver methamphetamine or cocaine, that's a C felony, possession of drug paraphernalia, methamphetamine or cocaine, a Class D felony, returning evidence of registration upon cancellation, some kind of misdemeanor, driving on suspended license, as in the more recent case, an unclassified misdemeanor. On those charges in 186, how do you now plead?
Not guilty.
I'm noting your plea of not guilty. Court's going to set you down to reappear in that case. I've already set you by scheduling order for August 1st. You'll be back in court on August 1st. And your case is set for trial the week of September 16th. All right. Now you may be excused.